Hi everyone, I'm Jay, the Principal Migration Lawyer at Flow Migration Law, and welcome back. In my work, I meet couples who are by all accounts a perfect match, and there is a common belief among them. If our love is real, the partner visa process should be straightforward. But that assumption, unfortunately, can lead to preventable hardship, including the visa refusal that nobody wants. Today, I want to share a story of a client couple who came to us after their DIY partner visa was refused. Their journey is a powerful cautionary tale about common mistakes and why every single detail and every single deadline is critically important. And as always, please remember this information is for general guidance. Immigration law is complex, so it's best to get advice tailored to your personal situation. So let's set the scene. We have an applicant from the UK on a working holiday visa and her Australian partner. They were in a committed de facto relationship for 10 months, so they took the logical next step and lodged an onshore partner visa application themselves. They had even registered their relationship, gathered what they thought were the right documents, and submitted it all, feeling pretty good about their chances. To them, their case was simple and straightforward. But some time after they lodged, the Department of Home Affairs sent them an email. It was a request for further information, or an RFI. The case officer needed two things: more evidence of their relationship and police clearance certificates for the applicant. The couple saw the email. They knew they had to get to it, but life was busy. They both worked full-time, with the sponsor often pulling more than 50 hours a week. They figured they'd gather everything when they had a free moment. And that moment never came. Over the next 6 months, the department sent 2 more reminders. All 3 requests went unanswered. Eventually, the visa refusal letter arrived. The official reason given was that the applicant had failed to provide the requested police clearance certificates. When the distressed couple came to us for help, we started reviewing their file, and we quickly realized the missed police check was only the tip of the iceberg. The initial application they lodged had very significant weaknesses. First, there was a critical lack of evidence. There were hardly any documents uploaded to prove the 4 pillars of their relationship: the financial, social, household, and commitment aspects. The file basically contained just a few photos, their passports, and a couple of flight tickets. And second, the Australian partner had never even submitted the mandatory sponsorship application form. As I said before in my previous videos, this isn't optional. It's a fundamental part of a successful partner visa application. So while the visa was refused for a simple failure to provide a document, the truth is, it was already standing on a very shaky ground. A visa refusal isn't always the end of the road. We decided the best path forward was to lodge an appeal with the Administrative Review Tribunal, or the ART. Our job was twofold. First, we had to address the specific reason for refusal. But more importantly, we had to build the entire case that should have been presented from the very beginning. We worked closely with the couple to gather comprehensive evidence, detailed relationship statements, statutory declarations from family and friends with specific stories, and documents covering all 4 pillars. We also submitted the properly completed sponsorship form. We presented this entire body of evidence to the tribunal with legal submissions. The tribunal member was satisfied. The case was sent back to the department, and soon after, their partner visa was granted. So what can we learn from this? Well, the most important lesson is to never miss a deadline. A request from the department is not a casual suggestion. It's a formal notice that can lead directly to refusal if ignored. It's also an opportunity to strengthen your case, and ignoring it is a missed opportunity with very high costs. This case really shows that a DIY application is a substantial undertaking. You must be prepared to dedicate the time to manage it properly. As the principal migration lawyer here, I, Jay, bring over 8 years of dedicated experience in Australian migration law. We guide applicants through the entire process, ensuring every detail is managed correctly. If you're preparing a partner visa and you want to discuss your application, please contact us for a free 20-minute discovery call. And if your application has been refused, and you need experienced legal representation for an appeal at the ART, you can reach out to me directly by emailing js@flowmigrationlaw.com.au to book a consultation. If this was helpful, please give the video a thumbs up and subscribe. Thank you for watching.